We'll have 20 minutes. Mr. Riley, you are responsible for watching the clock to reserve a portion of that time for rebuttal if you desire. Also, we've read the briefs. We have discussed this case in conference. We are familiar with the facts. Please take that into account during your presentation. At this point, Mr. Riley, I'm going to have you proceed. I will give you a 5-minute warning when you are getting close to the end of your time and when you're ready.
Thank you, Your Honors. Because you have read the brief, and the brief is pretty long, I'm going to cut to the chase on this particular scenario. When it all comes down to it, you can see all of the background associated with it, how we got to this particular scenario. But what really drives it is the agreement that was made between myself and Carpe Diem to provide them with 6 new classrooms in exchange for an absolution of all of the debt that we had owed to Carpe Diem. It was a very quick contract. It had to be done before the beginning of school, such that they could be able to accommodate their new frame of learning, if that makes sense. The contract was performed with the scenario of them being able to commence school on a normal schedule, which they did. They started school right in line with the schedule when they were supposed to start school. ARS 32-1181A-7A defines substantial completion or substantially complete, means the stage of the progress of the work on a construction contract when the work is sufficiently complete such that the owner can occupy and use the work or such portion of the work for an intended purpose. In this particular situation, it was complete before the beginning of school for them to be able to use the facility.
Mr. Riley, I'm going to stop you there. I've got some questions. Okay. Doesn't this predate that? Don't we have to go back to what initially happened? What initially happened was you borrowed money and you voluntarily executed a lien. Am I missing something?
No, that is correct. But
the lien was on your personal property. Is that correct?
That is correct.
And that kind of relationship between you and Carpe Diem was that of lender and lendee at that point. Would you agree?
Yes.
Okay, so that's how this whole thing started. You voluntarily executed a lien against your property pursuant to a contract to borrow funds. Is that what I'm getting?
That is correct.
Okay, so given that, that's how the lien initially got placed on your property. Is that right?
That is correct.
So then you're jumping forward to a different contract that it kind of appeared took place mostly by text messaging about an accord that you came up with. You're going to build the classrooms, they're going to forgive your debt.
That is correct.
Okay, so the lien was there because of the contract for money lending.
Correct. And in the
so
lien,
how do you jump from the lien being pursuant to a contract to the lien now becoming something that has to do with a construction contract?
Because the lien is tied to the construction contract because the verbiage in the lien specifically says that the lien shall be in place only until such time as myself, Jimmy Riley, has repaid the debt to Carpe Diem. So in order to determine how the debt was going to be repaid to Carpe Diem, we take into consideration the construction contract, which was the text messages back and forth. And that text message specifically says that they will absolve all of our debt. So when the work was complete for the construction contract,
but Mr. Riley, isn't there an issue about whether the work was complete or that text message contract had been fully satisfied?
So I'm not following your question. I think that you're talking about the issue of the baseboards.
No, what I'm talking about is you have a very clear contract for the lending of money and a lien that's placed on, that's all pursuant to a contract, agreed?
Yes.
And that contract contemplated you paying Carpe Diem back $150,000. Is that correct?
Correct.
Plus interest. Okay. So that's the first relationship. Then you go on to a second kind of relationship that is not really written out in a coherent document that you can say, here's my contract. But at some point in time, you guys agreed that you were going to build these classrooms in lieu of making payments, right?
Yes,
And in so doing, there were certain things that you were to achieve. Is that correct?
that they were to have the classrooms in time for school to commence. That's correct.
And you were going to pay all of the cost,
Correct.
all of the materials,
Correct.
all of the material suppliers.
Correct.
So at the point in time that you filed suit against the school, had all the material suppliers been paid?
There, all of our material suppliers, yes. There is an issue which they brought up at the Superior Court level. But if I may, Your Honor, that issue didn't come up until more than a year after the project was substantially complete. In other words, the construction was completed, the work was performed, they were into their facility, and they were refusing to release the lien on our home, which was payment for the work.
I hear what you're saying, and I understand what you're saying. What I'm telling you is this: you have a written contract, a written lien that you voluntarily executed, and it says, what is the language that you quoted out of the lien?
It says that it stays in place until the payments of the lien is paid until the. I'd have to look at the actual lien, Your Honor,
Okay,
but basically the gist of it is it stays in place until the funds are returned to Carpe Diem.
Right. And so you're arguing that substantial compliance in a construction context, which is completely different than a loan context, would you agree?
Yes, but the construction contract comes into place because that construction contract is what satisfies the loan contract.
And what document do you have to say when your construction contract was complete?
What document do I have to say?
Right.
Well, there's two things which would answer that question, Your Honor. One of them, the definition of substantial completion, which I just showed you, and then the undisputed fact.
Substantial completion is a construct of statute that is in regard to construction contracts. That's not what's guiding the transaction. What's guiding the transaction is the contract that you entered into initially. Do you see what I'm saying?
Yes, but the contract that we entered into initially says specifically in it that, and I'll have to find that here, Your Honor, but it specifically says in it that once the funds are paid, then they would release the lien on the property.
Did you pay them $150,000?
I couldn't pay them $150,000. We provided them $400,000 worth of work.
Well, I don't know what you provided them. What I'm telling you is if you had paid them $150,000 plus interest, that would be a clear and unequivocal completion of your obligations under the contract. Would you agree?
Yes.
Okay. But you've entered into a different kind of arrangement with them where you're going to construct a building of classrooms. And so how do we know when you satisfied your obligation for the $150,000?
Well, that would go to the contract that where it says in the text messages, would you be able to accept the work without cost to you as payment in full for the outstanding debt? If it's all inclusive, including electrical, so all we have to do is the data pools with no outlay to us, then yes, we can accommodate that. Excellent, let's begin. So that contract says this is how you repay the outstanding debt. We perform the work associated with the text message agreement. And then how do you know that the text message work was performed? There are two ways. One is a substantial completion for a construction contract that they began using the facility, and two is that the governing authority associated with the building issues a substantial issues a certificate of completion, which both occur. Does that answer your question?
No.
Then somehow I'm not understanding your question.
Okay. What in your text messages, first of all, best practice is always have a written contract. You would agree?
I would agree, but this was a very
Okay.
short time frame when we were trying to get this accomplished.
Okay. So you have text messages that say you'll do this, they'll do that, and eventually your lien will be released. Where in those text messages does it say that once that you have reached substantial completion or you've gotten a certificate of completion, they will remove the lien?
Well, that's a combination, because the text message agreement itself says right in it, as soon as the work is complete, they will take that as payment for all the outstanding debt. And then if you go back to the original agreement associated with the lien, it says that they will have no interest in our property as soon as the debt is paid. So if you tie those documents together, which you have to do, the original contract between us and them said as soon as they no longer have an interest, then they would release the lien. And the contract for the construction says perform the work and they will accept that as payment in full. So we did.
I have a different question when you're done, Judge Campbell.
Take it away, Judge Swan.
Well, Mr. Riley, you brought this action under ARS 33420C, but I don't see that you brought a breach of contract claim.
I brought it under 33420C because reading 33420C, it specifically says that once somebody has been advised that they have a lien on the property that is no longer a valid lien, they have to release the lien. And that's the reason that
Where do you see that language? Because I'm looking at the statute right now, and my concern is that 33420C may not apply to this situation at all. In other words, if you had paid the $150,000 plus interest timely and they had refused to release the lien, you might have a breach of contract action, but I don't see how you have a 33420C action.
Well, the 33420C, the language says a person who is named in a document which purports to create an interest in or a lien against real property and who knows the document is forged, groundless, contains a material misstatement, or otherwise invalid, shall be liable to the owner or the title holder for the sum of not less, and it goes on and explains what it is. And then down below, it explains a document purporting to, in section D, a document purporting to create an interest in, a lien, or encumbrance against a real property not authorized by statute, judgment, or other specific legal authority is groundless and invalid. So the lien was valid until the contract for the construction work was performed. And once the contract...
What I'm not seeing is anything in the statute that addresses documents which are valid when recorded, but later become outdated. For example, there are any number of liens recorded in this state for regular home purchase mortgages, and those mortgages will cite the principal balance of the loan at the time the loan was made. 20 years later, the principal balance may be substantially less than that, and the document is literally false at that point. It is not, however, actionable under 33420C.
Because it's not groundless, because the payments haven't been made in full. It becomes groundless as soon as the payments are made in full. And so that's the issue here, is that when you take 33420C and 33420D together, it becomes groundless, the lien becomes groundless once the work that was used in substitution for the cash was completed.
Okay, so we have an issue then of interpreting the statute to determine whether it applies only to documents that are false when recorded, or whether it sort of constitutes a big ear that listens to everything that happens over time and kicks in when a document is no longer true. That's a statutory interpretation issue that I have not seen any authority on. Have you?
5 minutes.
So, Your Honor, my particular scenario here, I guess, if I may take the last, may I abstain from answering that question and let him go and then use my last 5 minutes at the end?
It's
If you want, that's okay with me as the questioner. I'll defer to our presiding judge.
that is fine. So we will reserve 4 minutes and 30 seconds for Mr. Riley's rebuttal. All right. So at this point, Mr. Hall.
Good morning, Your Honors. This is Patrick Hall, and I don't really have a whole lot to add to what's already been written in the brief. To answer the most recent question about whether there's any authority on how to interpret this particular statute, I don't recall seeing anything. I looked for it. I do think that the statute's a little unclear as to whether it applies at the time a lien is filed, but it certainly seems like the statute was intended for the purpose of punishing someone who goes out and files a wrongful lien and knowingly does that in bad faith. It doesn't seem like the legislature had any intent to draft something to punish someone in a situation like this, where there's a good faith dispute over the validity of the lien.
When you read the statute, it says specifically, a person who is named in a document which purports to create an interest in or a lien or encumbrance against real property, and who knows that document is forged, groundless, contains a material misstatement or false claim. So wouldn't you have to know when you created the document that it was false, forged, etc.? I mean, that's the way I read it. What am I missing? I don't see it being ambiguous at all.
Well, that's the way I read it too. But unfortunately, there's no case law that directly interprets that. The issue that's been raised by the plaintiff in this case has never been addressed by a court, as far as I know.
Well, let me challenge that interpretation. The statute as a whole seems to be aimed at the act of recording, but interestingly, subsection C doesn't talk about the act of recording as the triggering event for damages. What it talks about is the knowledge of a person named in the instrument and the refusal to release or correct the document. Now, I would think that if the legislature wanted to say something more clear about restricting it to documents that were bogus when recorded, it would have said a person who records a document. But it doesn't say that. And so how are we to place that ambiguity in the context of the overall scheme of 33-420?
I'm sorry, are you asking me that, Your Honor?
Well, it's your argument.
Okay. I didn't know if you were cross-talking with...
No, this is the Court of Appeals. We don't do that here.
All right. Yeah, I honestly don't know the answer to that question. I think what my focus has been in this case is that the case law that has interpreted this statute clearly points out that there has to be bad faith and there has to be a knowing violation of this statute. And there's no evidence of that in this case. The trial court interpreted the parties' contract.
Hold on. It sounds like you're sort of conceding the question that I asked and moving on to the facts. Is that right?
I'm not sure I understood your question completely.
Well, let's make sure you do, because it's pretty important to the case, I think. My question is whether the statute covers only those instruments that are defective ab initio, or whether it also covers instruments that are that become defective. And the language, unfortunately, the legislature uses the passive voice in the first sentence of the statute, right? Great draftsmanship. A person who is named, but it doesn't say a person who records. It doesn't make the focus the act of recording, except perhaps in the context of the whole statutory scheme. So I'm wondering how we get to the idea that let's say hypothetically Mr. Riley had paid back all the money plus interest the next week after the money was advanced, and then your client refused to release the lien. Would an action be possible under this statute or not?
I think so, Your Honor. I do. I don't think in this particular case, though, and the reason why I'm diving into the facts at this point is that regardless of whether that's possible in a situation where someone repays a loan and then the lender refuses to release the lien, that's not what happened in this case.
No, it's not, but it's an interpretive aid for the statute. And I think before we can really apply the facts, we need to understand the law. And the law here, I think, is a little ambiguous. So you're saying that if it were a clear-cut case of repayment in a timely fashion, followed by a refusal to release the lien, that an action under this statute would actually be possible?
I believe so, Your Honor. That's the way I interpret it.
Thank you. That answers my question. Thank you.
Okay. So anyway, to get to the facts of this case, and the reason why I don't think it matters whether the statute would apply to the repayment of a loan and a refusal to release a lien, because that's not what occurred in this case. And this statute's clearly intended to punish people who knowingly maintain a lien or file a lien in bad faith. And in this case, my client had an initial loan agreement with Mr. Riley that he failed to pay back. And then they took steps to try to resolve that by giving him a chance to build 6 classrooms, provide them with an accounting, and ensure that all of the cost of materials were covered by Mr. Riley. And he breached all 3 of those promises. And my client continued to maintain that lien because of that. In fact, they had a third party threatening litigation against them before this lawsuit was filed. And even after the lawsuit, my client worked with Mr. Riley to try to resolve these issues and give him a chance to re-enter the school and finish construction. They continually asked for an accounting to be provided. And to this day, they still have not been provided any kind of confirmation that all of the third-party material suppliers have been paid off. And when we went to the trial court agreed with the school's interpretation of the promises that were made between the parties. And so if the trial court is agreeing with the interpretation that my client made, there's no basis to be able to prove bad faith or a knowing violation of this statute. And because the facts are undisputed, and because the trial court had the job of interpreting the party's contract, and it interpreted that contract the same way the school did, I don't think any of Mr. Riley's arguments about substantial completion matter. And I would simply leave our argument at that we have a good faith interpretation of the contract and absolutely no evidence of bad faith on the part of my client. And I don't know if there are any other questions.
Judge Winthrop?
No, I don't have any questions. Thank you.
Judge Swan?
I don't either.
Very well. Thank you for your argument, Mr. Hall. Mr. Riley, you've got 4 minutes and 30 seconds.
Thank you, Your Honor. In answer to your previous question, there's a supplemental agreement which was signed by Carpe Diem Academy and by Jimmy Riley. And in that it says, as soon as the original loan is repaid, Carpe Diem will no longer have any interest in the aforementioned property. Prior to that, what it says, in consideration of the loan received from Carpe Diem and for the security thereof, Jimmy Riley hereby grants Carpe Diem partial rights to the property. Carpe Diem shall retain partial rights to the property and shall have the right to obtain an interest in formation property so long as he has not repaid the principal amount of the loan. So then if you go to the statute, to answer your question, 33420C says a person who is named in a document. 33420A says a person who purports to claim an interest. So the difference is 33420A is somebody who files the document themselves on their behalf. 33420C says if there's a document in which this person is named and it creates a groundless situation, then that document needs to be modified or removed. And the answer to the question that you asked Patrick Hall was, if we had paid back the $150,000 and the interest 1 week later, would we have a case if Carpe Diem refused to release the lien? And his answer was yes, because we would have a case. The only difference is instead of paying back the $150,000 in cash, we paid it back with a $400,000 construction contract. So the difference between A and C in 33420 is what answers your question. One of them is the person who's actually filing the lien, and one of them is the person who's named in a lien. So if they're named in a document and somehow that document becomes invalid and groundless, which is defined by 33420D, then they have to modify that document or release it. They just can't keep it in place. That's the basis of the argument. Does that answer your question? Did I lose you?
No, we're still here. Whose
Okay.
question were you addressing? Judge Swan's?
Yes.
Okay. You're muted.
I'm muted?
No, Judge
No.
Swan is.
I was muted and I was about to lose power. So all that's been rectified and that answers my question. Thank you.
All right. Anything further, Judge Winthrop?
No, thank you.
All right. I thank you, Mr. Hall. I thank you, Mr. Riley, for your arguments here today. We will take this matter under advisement, issue a written ruling in due course. Be safe and happy holidays. We are at recess.
Thank you.
Thank you.